So let us continue with the next part. It is dating of prospectus and particulars to be contained therein. Okay, so basically prospectus concept we have studied in detail. Though that same knowledge you have to bring it here. So look at the details that is in prospectus when they are going to issue. Okay, what all contents have to be included. First, the instrument constituting or defining the constitution of the company. Instruments as in all the documents defining the constitution of the company. Okay, the framework. The provision under which the company was incorporated. Okay. The address of the place in India where such particulars in English, either original or translated copy, can be inspected. So A, B, C are basically talking about instrument, about the constitution. Second is provision under which company got incorporated, so which section it got incorporated, and address in India where you can go and inspect the above two documents. However, understand, if you look at the last point, they say ABC is not applicable in respect of prospectus issued after 2 years after company has commenced the business. So if 2 years are over and company has been in existence, commenced the business, then ABC have not to be filed. Then in that case, only you have to do what? D, E, and F. What is the D? The date on which the company was incorporated, the country in which the company was incorporated, and the address of POB in India. So date of incorporation, foreign company where you are, India where you are. So POB in India, incorporation in which company, country, and a date of incorporation. Only 3 details have to be given. And the above 3 will be given only and only if you are in existence for less than 2 years. So instrument constituting the instrument dividing the constitution. Then they're talking about provision under which the company got incorporated, and the place in India where you can go and find these documents to be inspected. These 3 you don't give it if it is a old company. If it is a new, then you have to give it. Remaining is quite logical. Date of incorporation, principal place of business in foreign country, and here in India where is the POB. Okay, address of POB in India. Those have to be included as a part of prospectus. Provision as to experts' consent and allotment, same as that of what we studied in the Companies Act. Same it is, like what we studied for prospectus from 20, all the provisions from 23 to 42, what we discussed, those points will be given again here. Now, according to this section, no person shall issue, circulate, or distribute in India any prospectus offering for subscription in securities of a company incorporated or to be incorporated outside India, whether company has or has not been established, or when formed will or will not establish a POB in India. Meaning is they're telling something that is going to be outside India may or may not have a POB in India, or it is proposed to be established outside India, whatever is the criteria, that kind of prospectus cannot be issued in India. It cannot be circulated and all that. If where the prospectus includes a statement purporting to be made by an expert, he has not given or has before the delivery of the prospectus for registration or withdrawn his written consent to the issue of prospectus, with the statement included in the form and context in which it is included, or there does not appear in the prospectus a statement that he has given and has not withdrawn his consent as aforesaid. Meaning is same thing what we have discussed, depends in the terms of expert. Either he has given the consent but withdrawn the consent, or the way it is appearing in the form and context is the wrong. And one more thing is what? That they're telling, they have not mentioned that he has given a consent and withdrawn the consent. Correct? See, when can you include the prospectus statement? When he has given a consent, not withdrawn a consent. And you give a statement very clearly that he has given the consent, but he has not withdrawn it. There anyone you don't fulfill, then that kind of prospectus cannot be circulated, cannot be issued, nothing can be done. Second, if the prospectus does not have the effect where an application is made in the pursuance thereof, of rendering all persons concerned bound by all the provisions of section 33 and 40 as far as applicable. That means if it is done, then it will be criminal liability, civil liability, all of those things. For the purpose of this section, statement shall be deemed to be included in the prospectus if it is contained in any report or memorandum appearing on the face thereof, or by the reference incorporated therein, or issued therewith. Meaning is only in the prospectus if it is there not included. If you're attaching it to the prospectus by any way you're showing it on the face, then that case we call it to be what? A statement included. If you look at the logic here, they're telling any prospectus relating to what? Issue of securities of a company, either incorporated outside India or proposed to be incorporated outside India. Whether they're going to have POB in India or not have POB in India, does not matter. You cannot issue, you cannot circulate such kind of prospectus when it has a statement given by the expert, where an expert had actually withdrawn the statement, or expert had given the consent, but he later withdrew it. Or maybe they have not mentioned it that he has given a consent and he has later withdrawn the consent. Then in that case, if such kind of thing is done, then in that case, we are saying that you are going to be punished under all these provisions 33 to 40 as applicable. Okay, simple it is. For this, I'll give you one question to be practiced. I think that will make it logically more clear to you. Then, section 389, registration of prospectus. We have already studied, can you issue the prospectus without informing ROC? No. Same thing here. Prospectus first should be registered with whom? ROC before circulation. It shall be approved by the chairperson of the company and two other directors. Remember it for MCQ. Approved by chairperson and two other directors. According to the company's registration of foreign company rules 2014, the following document shall be annexed to the prospectus, namely, in the prospectus, what all things you have attached? Any consent to the issue of prospectus required from any person as an expert. The expert has given a consent document has to be attached. A copy of contract for appointment of a managing director or a manager. And in the case of contract not reduced into writing, a memorandum giving full particulars. So already if you have appointed my managing director or manager, then appointment that letter, not a letter, a declaration like that. And if suppose you don't have it in document writing, then a memorandum. Memorandum means at least an information has to be given to them. A copy of any other material contract not entered in the ordinary course of business, but entered within preceding 2 years. Ordinary course of business not entered, but entered in the last 2 years. A copy of underwriting agreement and a copy of power of attorney if prospectus is signed through duly authorized agent or directors. So look at that. First is about the expert. Second, appointment of the managing director or any other directors. And if it is not available in writing, give a memorandum. If copy of any material contracts not entered in the ordinary course of business, but entered within preceding 2 years. Underwriting agreement, obviously, because issue of shares can happen through the underwriters. And finally, power of attorney. This will be only if power of attorney is signing on the prospectus instead of the directors and all that. Then power of attorney also you have to attach. Okay, now. Now, if you look at this, they've given you a definition regarding electronic mode. Basically, if you talk about Companies Act to me, I would say that this kind of definition won't be questioned. Like they say, that POB could be even in electronic media. Like it could be through the electronic mode also you can operate and all. But what do you mean by electronic mode? Obviously, we don't study a definition for it. But when you look at institute study material, they have given question on what you mean by electronic mode. So I would recommend you learn this. It could come. Okay. According to companies, registration of foreign companies, rules 2014, electronic mode means carrying out electronically based, whether main server is installed in India or not, including but not limited to. That is, you're carrying on electronically some activity. Whether server is in India or it's not in India does not matter. But electronically, you're carrying on an activity in India. But is not limited to means inclusive definition is there. Business to business and business to customer transaction, that is B2B or B2C transaction, data interchange and other digital supply transaction. Data interchange as in KPO, BPO services, all of that, or other digital supply transaction. So B2B, B2C, okay, any digital transaction, everything will be included. Offering to accept deposit or inviting deposit or accepting deposit or subscription in securities in India or from citizens of India. So if you're inviting foreign companies telling Indian citizens to subscribe in their securities, or you're accepting deposits from Indians, okay, that also is considered to be what? Businesses transaction. That's called electronically done. Financial settlements, web-based marketing, advisory and transactional services, database services, and products supply chain management. Any and everything done in India electronically is considered to be what? Business carried on electronically through the electronic mode. Financial settlement you're doing, banking payments are done. Web-based marketing, internet you're using for marketing purpose. Advisory and transactional services, just a transaction has been processed. Database services, data storage in India. Product supply chain management, any part of the supply chain is in India. Be warehouse or anything. Then in that case also we call it to be what? Electronically operating in India. Online services such as telemarketing, telecommuting, telemedicine, education and information research, and all related data communication services. Whether conducted by email, mobile service, social media, cloud computing, document managing, voice or data transmission or otherwise. Nothing they have left. So they're telling in this entire sector where we're using the word electronic mode, it could mean anything and everything done via to the email also, through computer systems also, it could be by cloud computing also, it could be by mobile phones also, anything, whether B2B, B2C, any data interchange, accepting deposits, securities, any kind of financial settlements you're doing, web-based marketing you're doing, advisory you're doing, or maybe advanced services like telecommunication, telemarketing, okay, all of these things, whatever you do, okay, either by computer, either by mobile, anything, all will be considered to be what? Electronic mode. See, this has been questioned as what do you mean by electronic mode? So I would recommend you study this. This as well as the next one also. Now we discussed that, you have to file the director's details. Okay, regarding secretary's details and all that you have to file. So what details are you going to find? That is important. In relation to the nature of particulars to be provided as above, the company's registration of foreign companies rules 2014 provide that the list of directors and secretary or equivalent by whatever name called of the foreign company shall contain the following particulars. Like if you turn back the pages, the first question we studied was what? Documents to be filed with the registrar in FC1. Then it was given what list of directors and secretaries. Correct? So this list of directors and secretaries containing details. So what actually details we require? So details are personal name and surname in full, any former name and names and surname or surnames in full, former names, whatever you were called, father's name, mother's name, spouse name, date of birth, residential address, nationality. If the person's present nationality is not the nationality of the origin, his nationality of origin. So it depends if you are a change to nationality, then where it was earlier, that also has to be given. Passport number, date of issue, country of issue, income tax PAN number, if applicable, occupation, whether directorship in any Indian company, other directorship or directorship held by him, membership number and email ID. Membership number for secretaries only. I think here my help will not be much. You simply have to learn this. Okay, so personal name, formal name, father name, mother name, everything, all your general details that you're supposed to give, where passport, income tax details, directorship number in India, all that will become important. So you have to give DIN and SIN. SIN because for the company where you're director, and DIN because that is your director identification number. Everything has to be given. Secretary means membership number also has to be given. So there are all the details that you're going to include. Something new here is former name, and one is if you're a different origin, if you're now a citizen of a country other than the origin country, then where it is the origin also. That also you have to give. Clear? All right. Then, next one, offer of Indian depository receipts. What are Indian depository receipts? Basically, these are foreign securities, but they are traded or they are being made available in India through the Indian banks. So we have the Indian depository banks. They are, helping us invest it, but they are securities of what? Foreign companies. So how these foreign companies can issue securities in India, how much securities can be traded here, how much floating of this money can be done, how much investment can be done. For that, all the rules will be made by the central government. Okay. According to Section 390, notwithstanding anything contained in any other law for timing in force, central government may make the rules applicable for the offer of IDR. So whether you can make IDR in India or not, that means foreign companies issuing their securities in India through Indian merchant banks, that is Indian depository banks. All sanctions should come from whom? Central government. The requirement of disclosure in the prospectus or the letter of offer. So when you're going to come with IDR, obviously you're going to have prospectus or letter of offer. So the content there will be decided by whom? Central government. Then the manner in which IDR shall be dealt with in depository mode and by the custodians and underwriters. To understand, custodian is the one who's having the control over the securities. Underwriters are going to act like agents, and these bankers. How much they can trade, how they can trade, all the transaction process, everything will be determined by whom? Central government. The manner of sale, transfer, transmission by a company incorporated or to be incorporated outside India, whether the company has or not has established or will not have established base of business in India. So basically, with respect to IDR, Indian depository receipts, that is in India, depository, in India, this transactions are happening, but they're all the securities of foreign companies. But about IDR, every and everything will be decided by the central government. That means that foreign company will not decide how much in India, how they're going to sell, transfer everything, how prospectus they're going to issue, content of prospectus, everything. Foreign company will not decide. Foreign laws will not decide. If it is going to be rooted in India, Indian central government is going to decide about it. So issue, sale, prospectus, letter of offer, contents, everything. Central government is going to decide with respect to Indian depository receipts. As per Section 390, a company incorporated outside India, whether or not it has established place of business in India, or whether or not it is a foreign company, to issue IDR in accordance with the rules prescribed by central government. So in India, if you're going to have your shares offered, it is going to be through central government requirement. A company incorporated outside India, having share registration office in New Delhi, means they have POB in India, shall issue IDR as per what? Central government requirement. A company incorporated outside India having shareholders who are Indian citizen means what? Again, foreign company for us. So in that case, we are going to say IDR will be as per whom? Central government. A company incorporated in India, but all the shares are held by foreigners, cannot issue IDR. Okay, that's quite understandable. You cannot issue IDRs. Please mark that to be important. A company incorporated in India, it's an Indian company, but all the shares are held by foreigners. IDR cannot be issued here. Then application of section 34 to 36. 34, 36, all we study as a part of prospectus, criminal liability, civil liability. Correct? All of that, putatus applicable here also. Section 391 of Companies Act 2013 provides for application of section 34 to 36 and chapter 20. According to this section, okay, according to subsection 1, the provisions of section 34 to 36, both inclusive, shall apply to the issue of prospectus by a company incorporated outside India, okay, and the issue of IDR by a foreign company. So if IDR is issued by a foreign company, obviously IDR will be issued by a foreign company, and if prospectus is issued by a foreign company, then in that case, if there is any material misstatement, omission, or in form and context that appearing to be misleading, or if fraudulently trying to induce somebody to invest in the company, all of these matters will be considered to be criminal civil liabilities. 34, 35, 36, mutatis applicable. Subsection 2 provides that, subject to the provisions of section 376, the provision of chapter 20 shall apply mutatis mutandis for the closure of the place of business of foreign company in India, as if it was a company incorporated in India, in case the foreign company has raised money through offer or issue of securities under this chapter, which have not been repaid or redeemed. Obviously, if you don't repay and redeem, then the binding of orders will be passed. So it will be happening in the same case, even in the case of foreign companies. Then penalties are given, which you have to do it. The punishment for contravention may be summed up as follows. Fine on defaulting foreign companies in the range of 1 lakh to 3 lakhs. In case of continuing default, additional fine to the foreign company 50,000 per day first, then with the continuation as it goes on. Punishment for every officer of foreign company who's in default shall be imposition of fine of 25,000, maximum 5 lakhs. I don't think so. It will be tested in the exam. Then, companies' failure to comply with provision of this chapter not to affect the validity of contracts. See, if the companies are not complying with this chapter 22, okay, then basically, what will happen is they will be punished and officers will be imprisoned and all that. However, contracts entered by the company will not become void ab initio. That will not be the criteria. Because what happens, contract you have entered with other companies, other people. So those will not suffer because of your negligence. So you will be punished, penalties will be levied on you, contracts will continue as it is. Any failure by the company to comply with provisions of Chapter 22 of the Companies Act 2013 shall not affect the validity of any contract, dealing, or transaction entered into by the company, or its liability to be sued in respect thereof. However, the company shall not be entitled to bring any suit, claim any set-off, or any counterclaim, or institute any legal proceeding in respect of any such contract, dealing, or transaction until company has complied with the provision. That means they're telling nobody is going to accept your suit or filing of you against others unless you comply with the provision. Others can file on you, no problem. But you cannot file unless all the provisions have been settled by you. Okay, last. Exemption under this chapter, central government may make some orders and say that certain transactions or certain provisions of this particular chapter could be exempted to certain class of foreign companies. The central government may, by notification, exempt any class of foreign companies, companies incorporated or to be incorporated outside India, that the company has or has not established or informed may or may not establish a place of business in India, as may be specified in the notification, from any provisions of this chapter, and a copy of every such notification shall, as soon as it made thereafter, shall be laid before the House of Parliament. So central government has the power of exempting you, but complete power is not given. It has to be laid in the House of Parliament for discussion purpose. Okay. So here I don't think so. There's something very complicated or something very serious to be, discussed upon. You should only go through once, read it, because content part is very less and you can connect very easily to company law. However, here you have to really focus on question bank. These are important questions for you to mark. Okay, I believe it to be very important. I just mark them. Please see that you do it without fail. Question number 3. Question number 4. Question number 6. Question 7. Question 7, rather you learn it only properly. Okay, learn it because it's same about balance sheet, P&L, all those things. You have to learn it properly. Question 9. 8 also. Question 12. 14. 15. And 15. These questions have to be done by you perfectly. You'll be able to tackle this topic very easily. In fact, I would say if you're doing it with me, if you have read it with me, along with me properly, then you'll be done with this chapter reading, the questions part of it. Now concentrate on the question bank, because in the question, all the concepts are again covered. So especially the question which I have marked is covering the entire chapter. So do the questions first, then see if something is still left out, then you cover the remaining. I would really ask you to focus on the question bank here, because first time questions are going to come. So obviously, they'll be focused on the institute material questions and the kind of questions given there. So I would highly recommend that you see the type of questions coming up and see the kind of answer that you're expected to write. I think that will be a thorough preparation for this chapter. Nothing more is required. These 12 questions or 10 questions which I have marked, see them, you do it thoroughly. That is actually covering all the content. All the 17 questions which we have discussed now as a part of theory are all covered by those questions. So basically, the crystal clarity of the concept also will be with the question bank. So I would recommend you do like that. In exam, 100% you'll have a question on this. Okay. Now, as I promised you about the share capital revision, and I told you I'll not be giving you now, I'll be giving you a little later point of time. So wait for the appropriate time. I'll be sending you the share capital revision, not immediately, but after a week's time. Okay. It will be solely for revising purpose, plus GDR and this thing, capital reduction to be discussed in detail. Okay. Remaining will be just a revision for you. Okay. But you have to wait for 1 week's time for it.